Is that, can y'all hear me now? Is that there or?
Yeah, there's a lot of echoing going on. I'm not sure what's.
Is that you, Roy White? Number U31888?
Yes, sir. Can you hear me?
Yes, sir.
Okay.
Okay, let's go on the record in cause number D40552-CR State versus Roy White. Counsel for both sides is present, defendant's present, and we are here for trial announcement. Are both sides ready to proceed?
Your Honor, I've been in communication with both my client this week as well as the district attorney's office. I believe that we've reached an agreement in this case, and all we need to do is set a plea date for it.
Okay.
That is the understanding of the state.
Okay. Do we want to get a date right now, or do you need some time to work out the final details?
I believe that everything's been worked out. If we could just get a date like in about 2 weeks, that way it gives me time to go over everything with Mr. White.
Okay.
Are y'all available either Tuesday the 8th at 1:30 or Thursday the 10th at 1:30?
Yes, either one is fine. I can be available whenever y'all need me to.
I can make either one of them work, Your Honor.
It's good with the state.
Okay. So, Mr. White, I'll just order you back. And I'm working on some other stuff as far as remote hearings versus in person. So just keep in touch with your attorney on how you'll appear, okay?
Yes, sir, I will.
All
And
right.
did we decide on the 8th or the 10th, Melissa?
Which would you prefer, the 10th?
Sure, thank you.
Okay, 1:30.
All right. We'll see you back then, sir.
All right, thank you,
All
Your
right,
Honor.
thank you.
That concludes this hearing. As far as Stutz, I'm not going to put anything on the record. I'll just make a docket entry to take it off the trial docket for now until he's appeared.
Yes, Your Honor.
Do we know if he's got an attorney? I don't even see if there's an attorney, so,
No one's been court appointed, Judge.
okay. And does the state have any communications with any attorney that may have been hired?
1 second, Your Honor.
I don't see anything in the file, but sometimes that doesn't necessarily mean that.
Correct. The state has not received any notice of appearance or had any communications with any attorney requesting this schedule.
Okay, thank you. The next one that I have is Brandon Nelson. Ms. Watkins, is that the client that's in the office with you?
Yes, Your Honor. I can kind of turn it. There's Mr. Nelson.
All right. Let's go on the record then in cause number D40546, State versus Brandon Scott Nelson. And I have counsel for both sides present. Defendants present. This is a trial announcement. And
Your Honor, I would report to the court that we've had this morning a new offer from Mr. Thompson that was emailed to me an hour or so ago, or I received it an hour or so ago. I've not had an opportunity to discuss that plea offer with my client. So we would announce not ready at this time in the hopes that we might be able to reach a plea bargain, but also inform the court that it's my understanding that the state has reviewed the indictment and determined that there is an error that will require them to take this case back to grand jury, which they intend to do, I believe, in June. So I do have a motion for continuance that is prepared and in order that I can e-file, but in light of that, I didn't know that that would be necessary because procedurally it's my understanding that this case will be dismissed and it'll be re-indicted to correct the error in the indictment.
They
okay.
agreed to a continuance, Your Honor.
Okay. So just give me that proposed order and I'll sign it. That way it's there. And then if there's a new indictment, go from there.
Okay, I will e-file that immediately. So
All
you
right,
don't need the motion, just the order.
You're making an oral motion to
Correct.
continue this case. Just give me the order. So the motion's granted.
Thank you, Your Honor.
All right. That concludes this hearing. Next one is Lena Henley.
Yes, Judge. I believe that's mine. I think Ms. Henley is with us.
Okay. Ms.
Judge, is my
Henley,
video coming through?
I'm here.
okay, you're Ms. Henley.
Yes.
Mr. Biltz, it looks like you're in Mars.
Okay, the Northern Lights, maybe?
Yeah, Northern Lights, maybe
There
not
we go.
Mars, because there's trees, so
Yes, Martian trees.
wrong planet. But we know that's your voice.
It's me, Judge.
It's a very distinguished voice.
Very distinguished.
Okay, and Ms. Henley, I'm sorry, raise your hand so I know who I'm. Okay, there, thank you. All right, we'll go on the record in D40537, State Visitors Lena Yannette Henley, and I have counsel for both sides present, defendants present. And this is a trial announcement, also a motion in limine that's scheduled to be heard, I believe.
Yes, Your Honor.
Okay. As far as announcement for trial, are both sides ready in this case?
Your Honor, the state would request a continuance. One of the key witnesses has an obligation that he cannot get out of the week that this would be going on June 29th. He would be available in July. However, due to a situation that he cannot control, the state would ask that if we could just continue this for the next setting.
Okay. So the state's oral motion, Mr. Biltz, do you have any objection or care to be heard?
Well, Judge, I'm prepared to make an announcement of ready.
Okay.
So I'll just leave it to the court's discretion about how to handle the motion to continue.
Okay. Motion to continue is granted. Give me an order. Record can reflect that Ms. Henley is out on bond currently. All right.
So Judge, will this excuse Ms. Henley from final pretrial and the trial date?
Yes, sir. Yes, sir.
And then I will advise her of the next trial setting.
Yes, that'll be the case. All right. That concludes
Judge, may I
this
be
hearing.
excused?
Yes, Ms. Henley, you're free to go. Annalisa Fandel.
This is mine, Your Honor. My client should be here, I believe.
Yeah, yes, sir. I am here.
She's the one that says power.
Okay. Well,
Sorry, I didn't pick that username. I don't know.
She does
how
sound like her. I can attest that's her voice. We can't see you, Annalise.
Oh, yeah, my camera's not working correctly. I'm sorry about that.
Okay.
Okay. We will go on the record in D40531 and D40529, Bustile State versus Annalisa Danielle Fandel. Counsel for both sides is present, defendants present. And I see that there's trial announcement, and also a motion to continue. Whose motion to continue is it?
Your Honor, it's my motion to continue, and the state has agreed to it, but they have a condition. So they're going to leave the current offer in place until next Friday, so the end of this coming Friday. So they agree to the continuance, but the offer expires next Friday.
That is the state's position, Your Honor.
All right. So the motions to continue are granted.
In other words, if my client doesn't accept the offer by next week, we're going to trial the way the the state has put it to me.
But not on the date that's set.
Not quite.
Correct.
Actually, Your Honor, if the defendant does not accept the state's offer, then the case is going back to the grand jury. The third-degree assault on a public servant should have actually been filed as a second-degree assault on a peace officer.
And I wanted an opportunity to sit down with my client next week where she and I could take the necessary time to look that over and make sure that if we accept it, we know what we're doing, and if we decline it, we know what we're doing too.
And I found
What you're saying is you want to know what you're doing.
Either way, I'd like to know what I'm doing. That's correct.
It's always good to know.
Yes. At least I have goals.
So the defendant's motions to continue are granted. I understand what the state's condition, I mean, their reasoning or what they're agreeing to the continuance for, and so I think everyone's on the same page. I'll just need orders, Mr. Green. That will excuse your client from this upcoming trial setting and trial now, final pretrial, okay?
Thank you, Your Honor. Yes.
All right, that concludes both these hearings. You're free to go.
Thank you. Annalisa, you're free to go as well.
Thank you, Your Honor. Thank you, Neil.
Okay.
Yes, ma'am.
Bye-bye.
Stephen Dobbs.
Your Honor, this is another one that a warrant is still pending for his arrest.
Okay, so as in the same, I'll just make a note here to take it off the trial docket until he's present in court, because we've never done an arraignment yet. So I'd like to at least do an arraignment before we could get into a trial, and I'd like to have him here at the same time. That would help.
Yes, Your Honor.
Okay. So nothing on that. Macy Zahn. I'm sorry. Christopher Barnson. I skipped one. And Mr. Aguilar, I think you said you were standing in for Mr. Keithley.
Yes, Your Honor, I'm here.
Okay, we'll go on the record in D40519, State versus Christopher Blaine Barnson. Counsel for the state's present. Joseph Aguilar is present, standing in for Steve Keithley, who represents Mr. Barnson. And again, a trial announcement. Are both sides ready in this case?
Your Honor, the state's ready.
Judge, Mr. Keithley says he's not ready. He says he would like to pass it for 30 days. He needs to discuss some mitigation and talk to his client about the reform plea offer.
Okay.
That's the notes I have, Your Honor.
Well, what I'll do is make a note that the state's ready, and obviously the record will reflect that too, and that the defense is not ready. Is that what you're saying?
Yes, Your Honor. I believe he wants a continuance.
Okay. I think I'd like for him to file a formal motion. I know that you're here on his behalf, but I'd rather him either put it in writing or make it orally. But so I'll make a note here. If you can convey that information to him.
Okay, so have him. I will, Your Honor. Thank you, Your Honor. May I be excused?
Yes, sir. So just make sure you tell Mr. Keithley and his client that this will remain on the trial docket until courts had an opportunity to review any motion he may file regarding a continuance. All right.
Will do, Your Honor. Thank you.
Thank you. Okay, Macy's on.
Hello, Judge.
How you doing, sir?
Good.
Is your client
I believe she should be over in the jail.
oh,
Here.
okay.
I think she's on the screen, Judge.
Mr. Barnson, you're free to go. You're free to stay, whichever you need to do. Free to go. Okay, this is cause number C38345-CR, State versus Macy, Diane Zahn, and I have counsel for both sides present. Defendants present. This court again was assigned by Judge Stubblefield, presiding this case for the County Court of Law judge. And Ms. Zahn, is that your full and complete name, Macy Diane Zahn?
Yes, sir.
Okay. And ma'am, are you the same individual that the court placed on probation back in 2018?
Yes, sir.
And at that time, the court deferred a finding of guilt and ordered that you comply with terms and conditions of probation. And since that time, the state's filed a motion to adjudicate, alleging that you violated terms and conditions of probation. Is that correct?
Yes, sir.
And it's the court's understanding, ma'am, that you're wishing to enter a plea of true to those allegations.
Yes, sir.
And ma'am, are you pleading true freely and voluntarily?
Yes, sir.
And do you understand the consequences of pleading true?
Yes, sir.
Mr. Perkins, do you wish to waive a reading of the motion to adjudicate?
I do.
Record can so reflect. Ms. Zahn, I have documents that appear at this time to have your signature on them. They are written waivers and stipulations on revocation of probation. There's a judicial confession and a waiver of your right of appeal. Did you sign these documents?
Yes, sir, I did.
Ma'am, did you understand everything you signed?
Yes, sir.
And did you understand that you have a right to have a contested hearing in this case?
Yes, sir.
Your attorney is Mr. Perkins. Are you satisfied with his representation in this case, on this motion to adjudicate?
Yes, sir, I am.
And Mr. Perkins, your client certainly appears to be sane and mentally competent. Is there anything your client has said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find that the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered her plea of true, that she understands the consequences of her plea of true. The court will accept that plea of true and take appropriate action based on the evidence. I have in front of me states 1, a judicial confession signed by the defendant. States he can have that exhibit admitted.
Yes, Your Honor.
Any objection?
No, Your Honor.
It's admitted. Anything further from either side?
No, Your Honor.
Not from the defense, Judge.
All right. State have a recommendation?
Yes. We recommend 2 years in the institutional division of TDCJ, probated for 4 years. Pay all remaining fines and fees, pay $1,030 in delinquent probation fees, $25 to Navarro County Crime Stoppers, anger management course, and confinement in the county jail for 50 days as a condition of probation with credit for time served, and pay current court-appointed attorney fees.
Ms. Dennison, I think that's the first time you've been here in my courtroom appearing on behalf of the state. And I was looking at Ms. Schumer thinking she was talking. I was like, her voice has changed. But now that I've gotten it down, it's Karen Dennison that's doing the talking.
Yes, Your
Anyway.
Honor, this is the first time I've been here on this side.
Okay. And I was wondering why Ms. Schumer's voice just didn't sound like it thought it should. But that being the case, Mr. Perkins, is that you and your client's understanding?
Yes, Your Honor.
Are you saying that you're reinstating my probation? No, that's not what you just said. Yeah, okay. It'd be cool if I could read it. Okay.
It's a reinstatement.
Thank you.
Okay. Based on the evidence, the court will grant the state's motion to adjudicate. At this time, the court will find the defendant guilty of the offense alleged in the indictment. It's the judgment of the court. She's sentenced to 2 years in TDC. However, imposition of sentence will be suspended for a period of 4 years, where she's ordered to comply with all terms and conditions of probation. She's also ordered to serve 50 days in the Navarro County Jail. with credit for those 50 days. Ms. Zahn, do you understand that you should, and assuming there's no holds on you, you should be discharged from the county jail this afternoon or this evening, whenever they can get to you?
Yes, sir. Thank you so much.
Okay, ma'am, you'll remain on probation.
Thank you very much.
Understand what's
Thank
required? Hold on, we're not done, ma'am.
I'm sorry.
I know you're ready to get out, but let's finish this up. You understand, if you fail to comply, there's a good chance you come back into the Navarro County Jail on a motion to revoke.
Yes, sir, I do.
Probation officer, ma'am.
My probation officer, Deborah Redden.
Okay. Well, you'll probably need to report to her as soon as you get out, or Ms. Ramos will give you some directions on when to report when you're discharged, all right?
Yes, sir. Thank you so much.
All right, ma'am. In this case, you've waived your right of appeal. That concludes this hearing. The bailiff's going to come over shortly and get your print on the judgment and on the docket sheet, okay?
Thank you.
Thank you. Good luck to you, ma'am.
You too.
Thank
Y'all have a
you.
good day.
Judge, may I be excused?
Yes, sir.
And Your Honor, may I be excused to come down to your court for the 2:30 in-person hearing?
Sure.
Thank you.
And Your Honor, may I be excused because that's my only case.
Okay, yeah, you too.
Thank you.
Probably wants to just X their boxes out. Jose Tarango? Like.
Sherry's got the file.
On the record.
Do you want it?
No, no, I don't want. I
Yeah,
want
that's
to
what
make
I-
sure that Sherry walks and bolt downstairs.
Yeah.
Say it again.
Before we go on the record, could I please speak with my client in a breakout room briefly?
Sure.
Thank you.
Bottom of the card. Karen. Put it on the bottom of the card. Yes, now that's where, unless Dana has changed, we've never, that's where we're disposed of, yeah. Yeah, she's, because, so did you, are you good?
Okay, so you ready to go?
Yes, Your Honor.
Okay. All right. Before we go on the record, this is a first degree felony?
Yes.
Hold on, next up, so I need to be. That's right here. But it's muted, so you can talk. Can I go down there and watch?
He's pleading guilty to the offense and an enhancement paragraph, is that correct?
That's right.
Yes.
Okay. All right, we'll go on the record in cause number D40807, State versus Jose Tarango. I have counsel for both sides present, defendants present. Mr. Tarango, is that your full and complete name? You'll have to unmute yourself, sir.
Yes, sir.
All right, and Mr. Tarango, you're charged with the offense of manufacture, delivery, of possession of controlled substance greater than 4 grams, less than 200 grams. And you're also, there's an enhancement paragraph that's been alleged against you. It's the court's understanding you're wishing to enter a plea of guilty to the offense in addition to the enhancement paragraph. Is that correct?
Yes, sir.
And do you understand, sir, what you're pleading guilty and true to?
Yes, sir.
All right. And Ms. Fallhaber, do you wish to waive the reading of the indictment?
Yes, Your Honor.
Record can so reflect. Mr. Tarango, I have documents that appear to have your signature on them. They are written waivers, written plea admonishments, a waiver of your right of appeal, judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir.
Did your attorney go over these documents with you? I'm sorry, Mr. Tarango, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything you signed?
Yes, sir.
You understand, sir, you have a right to have a jury trial in this case, and you're waiving that right.
Yes, sir.
You understand you also have a right to have the same jury assessed punishment should you have been found guilty.
Yes, sir.
Are you a citizen of the United States, sir?
Yes, sir.
This is a first-degree felony. It carries a range of punishment anywhere from, is this one where the range changes to 15 to 99?
It is, Your Honor.
Yes, that's what I thought. 15 to 99 years in the Texas or life in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. You understand the range?
Yes, sir.
Now, it's the court's understanding, sir, you've entered into a plea agreement with the state through your attorney. Is that correct?
Yes, sir.
The court will not agree to be bound by the plea agreement. However, if the court follows the plea agreement, it does cut off your right of appeal except by permission of the court. Do you understand that?
Yes, sir.
Are you entering your plea of guilty freely and voluntarily?
Yes, sir.
Do you understand the consequences, sir, of pleading guilty here this afternoon?
Yes, sir.
Your attorney is Ms. Fallhaber. Are you satisfied with her representation in this case?
Yes, sir.
Ms. Fallhaber, your client certainly at this point in time appears to be sane and mentally competent. Is there anything your client has said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of guilty, that he understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. I have in front of me states 1, judicial confession signed by the defendant. State seeking to have that exhibit admitted.
Yes, Your Honor. Roll offer states 1.
No objection.
It's admitted. Anything further from either side?
State rest.
Rest, Your Honor.
They have recommendation.
Yes, Your Honor. Based on the defendant's plea of guilty, his plea of true to the enhancement paragraphs and the evidence introduced, state is asking the court to find the defendant guilty of the offense alleged in the indictment, sentence him to 17 years of incarceration in the Corrections Division of the TDCJ, assess a fine in the amount of $5,000. Court costs in this case are $290. There's also a request for reimbursement to the DPS Crime Lab in the amount of $180. The defendant is entitled to 141 days of credit against this judgment.
Ms. Fallhaber, is that you and your client's understanding?
It is.
All right, sir. Based on the evidence, the court will find you guilty of the offense alleged in the indictment and find the enhancement paragraph to be true. It's the judgment of the court, sir, that you're sentenced to 17 years in the Texas Department of Criminal Justice Institutional Division with court costs, restitution, and that fine in the amount of $5,000 to be assessed. Any reason why sentence should not be pronounced?
No, Your Honor.
Mr. Tarango, you're sentenced to 17 years in the Texas Department of Criminal Justice Institutional Division. You are remanded to the custody of sheriff who will transport you to the appropriate facility to begin serving out the sentence. This sentence begins today. You are given credit on the sentence of 141 days, and any day thereafter you're awaiting transport to TDC. Do you understand?
Yes, sir.
In this case, sir, you've waived your right of appeal. That concludes this hearing. The bailiff will come over here shortly, sir, and get your print on the judgment on the docket sheet, okay?
Thank you, sir.
Good luck to you, sir.
Thank you.
Scott Tarango, Scott Aragon. Thank y'all for social distancing. I was in charge of that too, apparently. Don't know how that went to walk around with a tape. All right, Mr. Aragon?
Yes, sir.
Okay, this is cause number D38 164, State versus Scott Aragon. I have counsel for both sides present, defendants present. And Mr. Aragon, is that your full and complete name?
Yes, sir.
Mr. Aragon, are you the same individual that was placed on probation by this court back in 2018?
Yes, sir.
At that time, the court placed you on community supervision. The court actually deferred a finding of guilt for a period of 4 years. And since that time, the state has filed a motion to adjudicate, alleging that you violated terms and conditions of probation. Is that correct?
Yes, sir.
Before that time, there was a modification that was also done, and then, so here we are again. And so it's my understanding that you're wishing to enter a plea of true to the allegations contained in the state's motion. Is that correct?
Yes.
Are you doing this freely and voluntarily?
Yes, sir.
And do you understand the consequences of pleading true?
Yes, sir.
Ms. Fallhaber, do you wish to waive a reading of the motion to adjudicate?
Yes, Your Honor.
Record can so reflect. Sir, I do have documents that appear to have your signature on them. They are written waivers and stipulations on revocation of probation, a judicial confession, and a waiver of your right of appeal. Did you sign these documents?
Yes, sir.
And sir, did you have an opportunity to discuss these documents with your attorney?
Yes, sir.
She went over them with you, is that correct?
Yes, sir.
You understand, sir, you have a right to have a contested hearing in this case, and you're waiving that right.
Yes, sir.
All right, your attorney is Ms. Fallhaber. She's been on this case, I think, since the day you came into court and entered a plea of guilty and were placed on probation. Are you satisfied with her representation on this particular case in this motion?
Yes, sir.
Ms. Fallhaber, your client certainly appears to be sane and mentally competent. Anything that your client has said or done that would cause you to believe otherwise?
No.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of true, that he understands the consequences of his plea of true. The court will accept that plea of true and take appropriate action based on the evidence that's submitted. I do have in front of me states one, a judicial confession signed by the defendant. Stacey, can have that exhibit admitted?
Yes, Your Honor, all offer states one.
No objection.
It's admitted. Anything further from either side?
State rest.
Nothing further.
Okay. State have recommendation?
Yes, Your Honor, based on the defendant's plea of true and the evidence introduced, the state is asking the court adjudicate the defendant guilty of the offense originally alleged in the indictment and sentence him to 12 months of incarceration in the State Jail Division of the Texas Department of Criminal Justice, assessing $750 in fines, $309 in court costs, and $180 in restitution payable to the DPS crime line. The defendant is entitled to credit against this judgment in the amount of 447 days. By agreement, this sentence is to run concurrently with the 3 sentences handed down in the county court at law yesterday, cause number C39500CR, 39502CR, and C40674CR.
Ms. Fallhaber, is that you and your client's understanding?
It is.
At this time, the court will, based on the evidence, grant the state's motion to adjudicate. The court will find the defendant guilty of the offense alleged in the indictment. It's the judgment of the court that he is sentenced to 12 months state jail with any outstanding fines, court cost, fees to be assessed. Any reason why sentence should not be pronounced?
No, Your Honor.
Mr. Aragon, you are sentenced to 12 months in a state jail facility. You'll be remanded in custody of sheriff who will transport you to the appropriate facility to begin serving out the sentence. This sentence begins today. You are given credit on the sentence of 447 days, which I'm not very good at math, but I think that gives you enough time for 12 months. This will run concurrently with the other sentences you've received out of the county court at law. And I'll make a finding that you are presumptively entitled to receive diligent participation credit, although I don't think that'll be applicable in this particular case. So, do you have any other cases pending, sir, after this one? All right, sir. In this case, you've waived your right to appeal. That concludes this hearing. Bailiff will come over and get a print from you, sir, on a judgment and docket sheet, all right?
All right, thank you.
Good luck to you, sir.
Thank you.
May I be excused, Your Honor?
Yes, ma'am. Have a good day.
Y'all too, thanks.
Your Honor, in those cases that you granted continuance, are we bumping those to the 17th of next month, or is the court going to put this on a different schedule?
Let me think about it. I'll
Okay.
figure that out.
Okay.
Wilkerson. I have counsel for both sides present, defendants present, and this was set for a disposition on this case, and I know that the state has filed a motion to continue. I believe that, and correct me if I'm wrong, the defense is objecting, wanting to go ahead and get this over with. I certainly understand both sides' position. I spoke to counsel in chambers, and I'm prepared, unless there's been a change, to authorize a $5,000 PR bond on Mr. Wilkerson with the order that he not, well, I'll just say it's assumed that the court's ordering that he not,
You follow all conditions in your probation, no before using any fuel substances or alcohol.
yes. And actually, I have an order I just drafted, a general order. I'm going to do that and print that off and then come back in here and do that. And then we'll get a date to come back and finish this hearing. All right, sir? You understand? I'm going to do that right now. So I've got one. So keep in touch with your attorney, sir, but I'll be right back. I'm going to print this off now. And it'll be a $5,000 PR bond. You'll need to follow all terms and conditions of probation. And there's a good chance, sir, that I'll have you screened for drugs when you come back to the courtroom. All right? All right. I think that concludes this hearing, and we'll get a reset date from the coordinator, but keep in touch with your attorney. Yeah, I tomorrow by 9. By the time he gets out, hold on a second.
Just hope he doesn't come up here. Because you can't understand what happened. I don't know how court reporter would ever tell you that. Very, very quick action. I'm not making fun of him. I'm just saying he would be extremely hard to take down as a court reporter. Natalie sounds like a dream compared to you. Oh my goodness, yes. I mean, you can hardly have a normal. It's hard to get to you when you're not in court. Just talking to them. It's hard. You got to really pay attention when you're missing. Of course, I'm sure everybody says that. I mean, if I went to Spain, they would say, I'm not trying to be ugly. I'm just.
Melissa, do we have another date to come back? Did we decide that from either side or?
He's out. Whenever everybody's back on. Well, that's when you say vacations will start. It's gonna be a big. Yeah, they're actually doing some in-person training. I think you have the family law somewhere this year.
The original needs to stay in the court's file, but no, after they've file marked it, so. File.
Just saying that court order price, I don't know if there's a separate bond, but y'all have them sign over there. Did y'all get? But y'all do that. To do that. Which, that's what I thought, but I was making sure we didn't do anything else. He knows that. He knows that. He's there, are you? You guys are gonna have a good deal, I'm sure. Now we'll get water there. When they had their farm, they did. When they had their goods, before you was a little bitty kid, over. Yeah, when you were a baby, you were 10 or 12 in the jail, they had the, they had farms exposed over there, and they, oh yeah. These guys ain't getting the jail. Give them that they ain't there. Yeah. that they used to have to do it. Just some of those guys don't do it, too. Yeah, they got to, right? See, last. Thank you. See y'all next time.
Okay, so is he getting probation or is just wanting out on this?
Just calling again.
Okay.
Yeah.
That's my option.
Yeah, we're good so far.
Let me know.
I had it on there, but